Great, welcome back to House Healthcare. It is the afternoon of Thursday, May 4th. And this afternoon, we're going to be taking up several bills that passed out of here and are now coming back to us from the Senate. The first one is going to be H230. And we have legislative counsel here to walk us through the changes. Welcome.
Thank you. Eric Fitzpatrick with the Office of Legislative Counsel. Nice to see everybody. It does feel like I've been a while since I've been in here. So glad to be back. Explaining to the committee what the changes are to H230, which was an act relating to implementing mechanisms to reduce suicide. As the chair mentioned, it's passed the Senate, and they did make some changes to the bill as it passed the House. The document you have in front of you uses yellow highlighting to indicate where those changes are. So unless you have a different preference, I would just focus on those changes as opposed to the whole bill.
Yep.
Okay, great. So you'll see there are a few changes in the findings. The bottom of page 1 over onto the top of page 2 replaces a finding about suicide data with a more current data number that was from the Department of Health. So it's actually numerically not that different. It's only a couple of points off, but it's more current. So that's why the Senate chose to go with the more current data on that one. You'll see over on page 2, there's 2 pieces struck. One is finding number 7, which was the finding that persons at greatest risk of suicide in Vermont are men, persons living in rural areas, persons with a disability, veterans, and members of the LGBTQ plus community. And I think the Senate's perspective on that was, well, that may be true. They weren't clear about the relevance to the criminal provisions in the underlying bill. So that was the direction they took on that. The last sentence of finding number 8, they were a little unsure about because they weren't sure about what it meant that none of the respondents, this is the sentence, are known to have died by suicide. Well, they weren't sure if that meant they actually hadn't, or how firm a piece of data was. So they felt to err on the side of not being certain, they would strike that sentence. Subdivision 11, page 3, that has to do with straw purchases, and they felt straw purchases is addressed in a different bill, S4. So they prefer to have all.
And I think that might have been added by judiciary. Anyway, that was a judiciary finding. Yep.
Right.
Okay.
You're saying it that sounds familiar.
Yeah, I never remember that.
Yeah, that was the
So that takes us to the purpose. And over on page 4, you see that language was actually suggested by the Attorney General's office. They felt that in terms of potential future litigation, that not potential, but very likely future litigation, that it would be better for their defense of the statute going forward to be more specific and phrase the language in that way. So that came from their office. And so then we'll get to section 3, which is the substance of, you remember as it left here, was a secure firearm storage provision. If I sort of in the big picture for a moment, what's the shift here? And it looks like a lot of, and if you look at it, you're like, wow, there's a lot of yellow here. It does seem that way. But substantively, there's only a couple of differences. And the reason that you see all the yellow is because it's restructured. And it's restructured to be based on the New Hampshire approach. New Hampshire also has a safe storage statute. Theirs is called the same title that now has here on line 12, page 4, negligent firearm storage. And, I'd say the primary difference between, or a couple of the primary differences between the New Hampshire approach and what came out of this committee is that you may recall that the way it was set up, there was sort of a tiered penalty structure for not storing a firearm properly. And the way I think the very first version of the bill you looked at said, here's the requirements for storage. If you don't comply, there's a $100 fine. Anybody remember that? That's not the way it left. Ultimately, that was struck, but the provision remained that said the firearm must be stored in this particular fashion. Now, there wasn't a criminal penalty that didn't kick in until whether there were some consequences to that failure to store it properly. And those provisions actually remain exactly the same. And that's that it's a 1-year misdemeanor, $1,000 fine if a child or prohibited person gains access to it and uses it to commit a crime or displays it in a threatening manner. That's about on page 4. Over onto the top of page 5, it's a 5-year felony if a child or prohibited person gains access to it, uses it to cause death or serious bodily injury to any person. So that remains the same. But what is different by using the New Hampshire model is that piece where it says it's unlawful to store it improperly, even without one of those consequences, is removed. So you see the way it's phrased. It says it's only unlawful if.
Can you just say what line you're on?
Yes, it starts from line 13. The way it actually in line 13, the way it had left the house, it said a person shall not. Everybody see the struck lines, shall not. So the prohibition existed regardless, even if one of those more serious consequences didn't happen. Now, there wasn't any criminal penalty associated with that prohibition, but it was a prohibition and it could form the basis, say, for a civil lawsuit, or perhaps some enterprising state's attorney might try and use it for some other offense. But the Senate felt that since there wasn't going to be a criminal penalty associated with that, sorry about that, they didn't want to phrase it that way. They preferred the New Hampshire approach, which, as you see, does preserve the exact same criminal penalties for situations where the attendant bad consequences occur, but doesn't make it. So for example, if someone were to not store their firearm properly, or I say properly, in the manner required by the statute, and no bad consequences happen, then it's not illegal. So there wouldn't be, for example, a basis for a law enforcement officer to say, I'm going to get a warrant because I've heard that you might not be storing your firearms properly, and go into your house and search, because that wouldn't be illegal. It would only be illegal if subsequently there was a serious bodily injury or a threatening situation, that sort of thing.
Okay.
So that's the distinction.
Okay.
Is that comprehensible?
Yeah, does anyone have any questions on that section?
So just so that I understand, if I store, I'm the person,
Right.
and the weapon is under my jurisdiction.
Right.
Et cetera.
Yep.
So the only time that I get in trouble is if the kid gets a hold of it, because I didn't have it locked up, and commits a crime with it, or kills somebody or does something like that, right?
That's about right.
Only time that I get in trouble.
Right.
Okay.
Right. And to just sort of add on to that, in the first place, you have to, not only does it have to be under, the firearm have to be under your control, it has to be in a situation where you know or should know that a child or prohibited person is likely to gain access. So in other words, if you live by yourself, say, and you don't have kids come over and visit, then you wouldn't even be required to store it in that way in the first place. But your point is well taken. That's correct. That if one of those bad consequences doesn't happen down the road, then no, you're not going to be, it wouldn't be unlawful, or you wouldn't get in trouble for it.
And so then that would also transfer into a hunting camp.
Right. Absolutely.
Any other questions?
I got one. And under the new, looks like the new rule, what about theft?
Theft, you're already, there are defenses to that that were existing in the language that came out of here. So that, for example, if someone gains access to it as an illegal entry, which would result in a theft, for example, you're already, that's not a violation.
Okay, because that takes care of your hunting camp, you know, because how many hunting camps do you lock up when you leave to go downtown or something? I know. Okay, thank you.
So a lot of the language that you see struck is actually just moved. So for example, we just looked at those penalty provisions, bottom of page 4, top of page 5. That is identical to what's over on the top of page 6. It's just struck there, moved up front, because that's the way, more closely modeled to the way the New Hampshire statute was set up. Similar to the sort of list of exceptions that starts on page 5, subdivision 2, that's around line 8. And actually, one other thing I wanted to mention, right above that, you'll see that the way also, again, so restructuring does have a substantive difference in it though. And that's to move the locked container, secure firearm storage provision into the exceptions. Substantively, it doesn't make a difference. It just means that if you store it properly, or at least as required by the language, then you can't be charged with substantively exactly the same as the way you had it phrased. Just puts it within the list of other offenses, which is one of the ones you were just mentioning. I'm sorry, not other offenses, other exceptions, such as if you keep the firearm right next to you in close proximity, that's line 9 and 10, not changed. If you carry it on yourself or it's within close proximity that can be reasonably retrieved, then that's not an offense. Those haven't been changed. B and C as well. If it's an illegal entry, which is what you were just mentioning as well, if that's the case as to how the child or prohibited person gains access, that's not a violation. And the same with the act of self-defense in subdivision C. So you'll see a difference there, though, that the separate from ammunition language has been struck. That's line 18. So the difference there is that the Senate felt that if you have your firearm in a safe or equipped with one of these locks, then it would be okay for it to be loaded. So as long as it's in the safe, you can keep it loaded, is the way the structure is here. Again, that's the New Hampshire approach also. So it's not required to be separate from ammunition if it's properly secured.
Any questions? Okay.
All right, we already went through the penalty stuff. We just saw page 6, that was moved to the more front-loaded part of the criminal provision. The charging discretion, you remember that piece, that struck. That was providing that the state's attorney would have charging discretion if a child gained access to the firearm and then used it to sort of an unintentional self-inflicted shooting that caused death or serious bodily injury. I think the perception was that, and I think this committee and House Judiciary as well, where I think recalled that they had that discretion anyway. This was just more of a highlighting to the state's attorneys that this is there, and the committee downstairs felt that that wasn't necessary. Slight change to the warning. Remember, there's a warning that has to be posted at firearms licensees where they sell their firearms. You'll see that over on page 7. Instead of saying anything specifically about what firearms law requires owners to do with respect to storage, and not being clear that would be accurate given the other changes they made, they just opted for a statement that said failure to securely store firearms may result in criminal prosecution. And then that second sentence, it is important that the owner of a firearm seek firearm safety instructions from a certified firearms instructor and keep firearms secure from unauthorized use.
I got a question on that one. The law in the state of Vermont now is you do not need firearm safety instructors to own a gun. You have to pass a certified instructor's course to hunt. So are we making a new state law here?
Ask. Ask him.
No, it's all it says is it is important.
Oh, it's important.
It's not that it's
Okay.
illegal.
It's not mandatory. Okay.
Right.
Thank you. Sorry about that.
Yep.
Do you know what the Senate's thought process was on that? Like, where did that even come from?
It's verbatim from the New Hampshire warning statute.
Oh, okay. Okay,
Yep,
that's where it came from. Yeah.
exactly. The second sentence, not the first one,
Yeah.
right? Yep,
Just the stuff about the firearm safety
exactly.
instructions.
Yep, that's right where it came from.
Okay.
Let's see. So, all right. So that actually is the end of that section on firearm storage. I'll pause there for a moment before we get to the extremist protection orders.
Any other questions on that piece or comments? Okay.
So moving on to the ERPOs, the extremist protection orders, the The two main changes here are one in which the Attorney General and the state's attorneys asked for. You'll see this happens in a number of cases, and this led to the idea of party substitution. I don't know if you remember that specifically, but it's that, because you remember in the big picture, what was going on in this section was that right now, the petition for one of these extremist protection orders can only be brought by the Attorney General or a state's attorney. So it was expanding it to permit a family or household member to bring the petition. It also had procedurally, after the family or household member brings the petition, the SA, the state's attorney or the AG are substituted later on to be the plaintiff, to be the one who prosecutes the action after the initial petition is granted, if one is. What the AG and the SAs agreed on was, well, if it's one of those party substitution situations, it should really be the state's attorney in the county where the petition is filed who takes over the case, not the AG in Montpelier, who will have no connection to the geographic area necessarily and wouldn't have the same ability to contact witnesses, do whatever they would need to do to bring the case. So you'll see that done in a number of different spots, that where it initially said state's attorney or attorney general, now it just says state's attorney of the county where the petition was filed. And that's what that is referring to, is the substitution of the party after the family files. So speaking of the filing by the family or household member, the other substantive change is over on page 11. Right now, the ERPO process has two different burdens of proof. So in the emergency ERPO, that order that can be issued ex parte, right, without the presence of the defendant, the person can go in, get an order from the court and have the person's firearms removed without the person who owns the firearms knowing about it yet. It can only last 14 days for due process reasons, that because within that period of time, the court has to have a final hearing where the defendant gets notice and they can come and argue against it if they want to. Right now, that initial 14-day emergency order is under a preponderance of the evidence standard. That's more likely than not. It's a lower standard than the final order, which requires clear and convincing evidence. So there's three general levels of evidence in the law. Preponderance is the lowest, clear and convincing is the middle, beyond a reasonable doubt is the highest one, which is used in criminal matters. So what the change is, so under as I was mentioning right now, preponderance of the evidence applies in the emergency, clear and convincing applies in the final. The change is, you'll see on page 11, that if one of these petitions is filed by a family or household member, the higher burden of proof applies, clear and convincing. So it's not preponderance the way it would be if a state's attorney or an attorney general files it. It would be clear and convincing if a family member files it. And the rationale for that was that, well, in terms of being able to be sure that that a state's attorney and AG would have more access to and more knowledge about what the relevant standards of proof are, would be able to marshal the proper evidence for it, whereas that would be less available to a layperson, and that they should therefore be held to a higher burden of proof because of the potential for other ramifications that would happen if they filed without having access to or knowing about other evidence, that kind of thing.
Alyssa?
Do you think you could give us some examples of what the difference between preponderance and clear and convincing? What kind of evidence are we making family members come up with?
That question comes up a lot, and it's very difficult to answer in the abstract because, each one is so fact specific. So, well, this much evidence, because you think about it, you have a human being judge who's sitting there. In this case, in a ex parte situation, it's probably taking evidence over the phone from the complainant, whoever it's going to be, whether it's a family member. Like that's the way it happens in the RFA. They call them up over the phone. They swear to an affidavit over the telephone. But the one thing, without trying to say, this particular fact is preponderance and that particular fact is clear and convincing, because that's almost impossible to do in a vacuum. One thing I can say is that when the person calls up over the telephone in the RFA context, as well as this one, Judge Zoni was talking about this, they accept everything because there's no other party. right? At that point, there's no opposing party. There's only that person on the phone. And they've sworn to it, and they've sworn to the affidavit. And so they're accepting everything that they say as true. And so preponderance, very easy burden to meet in that sense. Not that it always gets met, because sometimes they deny them and they find that even that doesn't quite satisfy the evidentiary standard. But someone who was able to swear to, for example, not just their own personal interaction, could say, my son, for example, also witnessed this, or I called the police, and the police also came and spoke to this other person. In other words, could have other sources of evidence, not just their own oral statement over the telephone to corroborate what they were saying. The more corroboration you can get, the more likely you get to that clear and convincing threshold. So.
And just so I'm clear, right now, the RFA, current RFA, you only need a preponderance.
Yes.
You don't need clear and convincing.
Correct.
And do you happen to know by any chance, do they keep data on people who have submitted for like an RFA, that ones that have been turned down? Is that data that they have?
It is. I don't know it off the top of my head, but the only reason I know that it is because I do recall, I think it was Judge Zone, who was able to provide some percentages about this percentage were granted and this percentage were denied. I can't remember exactly what the numbers were, but yes, they did have some of that.
So because they made the evidence higher
Right.
for family members, we'll at least have evidence, or we'll have data in a couple of years over what's been granted and what hasn't, correct?
Yeah, that's a good point. Yep, you will. Yep. And would be interesting, just as you say that, I didn't think of it until you just said it, but it would be interesting if you do revisit that data, since, as you pointed out, it's a lower standard for the RFA. It would be interesting to compare them, right? See if we're a higher percentage granted in the RFA context because you had a lower, well, you wouldn't necessarily be able to make that correlation, but at least to know whether more were granted.
Yeah.
Art, and then Leslie.
Yes, Eric, we had a pretty extensive definition of household members. Is that left off because you're not? Is this off the whole bill that you have on here?
Yeah, I thought it was in here, huh? Oh, yeah, there it is. It just hasn't been, it's not highlighted because they didn't change that. They used the same one that
What
that you
page
guys
is that
said.
on?
Bottom of page 8, top of page 9.
Okay, so it's back there.
Yeah.
Okay. Gotcha.
But they
Okay.
didn't make any changes to that.
All right, gotcha.
Yeah.
Okay, thank you.
Sure.
Leslie?
So my thinking was going along where Alyssa's was, clear and convincing evidence. So what I'm hearing you say is you have other witnesses involved. Would a tape recording or a photograph that would be applicable?
Absolutely. Yep. Whatever you have that will be corroborating, that would go beyond your own oral statement over the phone would, again, I can't say, and if you had 3, that would definitely get you to clear and
I
convincing.
get it, but I just
Yes,
want
the
to
more you
understand
have.
what would qualify as clear and convincing.
Yeah, that would absolutely count. Yep.
All right, so I think we have one more section that changed.
Yeah, so they,
Added
well, just a little, you'll see it's really they did not make any changes to the waiting period, so that remains 72 hours. They did add, well, 2 other changes. One is a severability section. So this means that if one provision of this act, assuming it passes, if one provision is found illegal, unconstitutional, as I said earlier, it's very likely that there's going to be litigation around this bill. So you could almost be certain about that. But a severability provision provides that, if one section is found unconstitutional, that won't have any effect on the other sections of the bill. Technically speaking, you don't need that because in Title I of the Vermont statutes, there's general law that says any act that's passed, all sections are severable, but it's kind of like double secret probation, I guess. So, they want to have it in here anyway, even though technically it's not necessary.
Okay,
Right.
great.
And lastly, you'll see bottom page 13, they changed the title. So to add the community violence piece. So it's an aggravated implementing mechanism. See a typo there. But that might not necessarily be in the bill because this is a separate document. I will double check to see if that typo exists in the bill that's in the calendar, because it might not. This is a different document. Should be mechanisms, plural, to reduce suicide and community violence.
So any last questions for Eric on the changes from the Senate? Great. Thank you.
You're welcome. All right.
Because of the timing, we're going to hold our committee discussion and straw vote on this. We'll do it when we do 481. We'll just lump the two suicide prevention bills together. And we're going to move to 206. Thank you, Eric.
Sure. All right. Well, see you soon. Yep. Bye now.
All right. So 206. We're specifically going to focus first on the lien section. So David, come up and join us. So David will introduce himself in a minute, but I've asked him to join us and give a high-level overview of what problem we're trying to solve and why. I want to try to avoid getting really into the weeds of a lien process. Try and stay up here, so we'll see how we do. So if you want to introduce yourself and then go for it.
Okay, great. David Mickenberg here on behalf of the Vermont Association for Justice. Good to be here. First time with you all in this committee, so thanks for having me. This bill came about, there's been some, both in Vermont and nationally, some concern about what are really outdated lien statutes. The sort of lien law, and I'll explain what that is very briefly, came about at a time when, decades ago, when about 10% of people had health insurance. And so hospitals were finding themselves in a situation when somebody would be in an accident, finding themselves having an inability to recover their costs that they would serve. Somebody would come in, they would, take care of them. And then there was this other proceeding that was happening, and hospitals were finding it difficult to access reimbursements. So the law that we currently have on the books essentially says that if somebody is injured in an accident and they receive service in a hospital, the hospital can recover everything except for $500 of their expenses. So in this other proceeding. And
Not from the health insurance plan, from whatever proceeding might be happening.
Exactly, from the lawsuit related to a car accident. Somebody gets in a car accident, they have $10,000 in damages. The hospital has $10,000 in costs. They can now just wait until that lawsuit is resolved and get $9,500, leaving the injured Vermonter with only $500. That's what the current statute allows for. So the intent of this, and that does happen in Vermont, and what hospitals have done here, and not as bad in Vermont as other places. Hospitals, by and large, try to figure this out, but there are some that have asserted liens, saying they have a claim to the resolution of the, what's called, I'm trying to not do lawyers. I'm trying to not be like, the resolution of that auto accident case. Some hospitals will say, you come into the hospital, you say, I was in an auto accident. Immediately they can assert a lien. Even before there's a claim that's even made, they can assert it right away and say, we have a claim on all of our expenses less $500. And that has been problematic. So what happened, we brought this issue forward and worked with the hospitals, worked with the insurance companies, and worked with the healthcare advocates and others to come up with something which is more fair. And one of the things that was a detriment to people that were injured was that if a hospital asserted a lien, they would not be submitting claims to the insurance company. So you wouldn't be getting the benefit as an injured Vermonter, the benefit of your insurance. So you wouldn't be paying down your deductibles. You wouldn't have your insurance paying the costs of your care. What the lien would do would wait for the resolution of the lawsuit and collect what they could from that. So
And potentially leaving the person who was in the accident with only $500 on that.
exactly. Yep. That's what the current law says, that they can recover everything less $500. And that shows how old this, this law is. It's, what we tried to do here with this piece of legislation is to provide some fairness. We said, well, if you have health insurance, and 97% of Vermonters now have health insurance, which is a great thing. But if you have health insurance, then the hospital has to charge the health insurance, and you should get the benefit of the health insurance that you have. We did say that if you have deductibles and you don't pay the deductibles, that the hospital could recover that from the lawsuit for the car accident, deductibles and copays. We said that there would be some limitations, like most of the states that have these updated laws, on how much the hospital could recover. So I think what we did was strike a balance between allowing the hospitals to cover their out-of-pocket expenses, you say, uninsured people and for copays and deductibles, but also allowing an injured Vermonter to have some level of recovery that makes sense. If you get a lawyer, go file a lawsuit for a car accident, spend all that time and emotional energy working on the claim, and then end up with $500. It doesn't make a lot of sense. And it also complicates the whole process. So that's my attempt at highish level explanation of this, and I'm happy to answer any questions.
Any questions?
I have a question specifically around Medicaid.
Yeah.
So currently, somebody has Medicaid and they're in an accident. Medicaid will pay, and then Medicaid will then go after to get reimbursed. And we just did a bill on, was it 206 is even kind of like with that.
This is 206.
Oh, that's right. Okay, so when we talked about 206 6 months ago or whenever it was.
What are we talking about now?
So are we saying with this that Medicaid cannot go after it?
No, that would
get reimbursed?
No, this is specific to hospitals. That would be, Medicaid would have what's called a subrogation lien, meaning they would have a claim to get reimbursed from the lawsuit. So, yeah.
Megan?
I'm hungry.
Okay.
This is it next week, yeah.
By the same token, along the same lines, insurers would do the same,
Yes.
correct?
They would assert a subrogation lien against the.
So what it does is it shifts the burden to them rather than to the hospital of having to pursue.
Exactly. Yep.
Okay.
Yeah.
The factor being universal health insurance is kind of now what we do, so you go that way.
Exactly.
And do you recover all or still that $500?
For the health insurance?
Yeah.
Well, I mean, it gets, subrogation process is a little different. There's things like what's known as the common fund doctrine, when it's a principle of law, when there's a set of money and somebody else goes out and pursues it for you, you're allowed to offset for your time and effort to pursuing that. So subrogation is a whole area of law we could do.
Please don't.
I could bore you to death on it, but yeah.
Please don't.
I'll just throw out big terms.
And one other question for you, Lori. My brain must have shut off when we did this. I don't remember.
We did not. This is the Senate put this in. That's why your brain did not shut off. This is the Senate. The Senate added this in. And so now we have to decide.
Okay.
Yes.
Thank you. That's good to know.
Yeah, you're okay.
So I'm confused and I'm sorry.
Okay.
But in my understanding of the payment pathway, in the new world,
If this were to pass.
if this were to pass, an individual would get into an auto accident. This would allow the hospital to bill their insurance, whatever it might be, 4 charges generated as a result of that accident.
Correct.
So that's correct.
Yeah. This would require that.
That would require that.
Yeah.
That's a good thing. Why would there then be subrogation?
Yeah.
I don't even know what that is. If they're getting paid through the insurance company, why would the hospital go that path?
Well, the subrogation would be asserted only by the health insurance company, not the hospital.
Oh, okay.
This just addresses what the hospital can and can't go after. This is a hospital lien statute specific to hospitals. That second complicated term of subrogation relates to the health insurance and Medicaid
And that's not even addressed.
not addressed in this
Well,
building.
that's not an
in this
issue. I
bill.
shouldn't be
No,
thinking
it's
about
not.
it.
No.
Thank you.
It was just in response to the question of
I got
the
lost.
black.
Thank you.
Yeah, no.
So what it means is the hospital is required to go to the insurance company, whatever they get from the insurance company, that's it.
Yes. With the exception here that if there are deductibles that a patient is responsible for and doesn't pay it, then they could assert the lien on the deductibles or co-pays, yeah. I mean, some people have $10,000 deductibles, so it's not an insignificant amount. And in the conversations with the hospitals, it was something that was important and we, of course, thought it made sense.
I asked this the other day. Is this gonna mean that when you go to the hospital and they ask the question, was this due to an accident? Is that question gonna go away?
No. No, I mean, and not this.
It might have nothing to do with this.
Yeah, it won't go away for a variety. One, because you may have deductibles and co-pays. Two, if you're uninsured, obviously, then they can assert a lien within the parameters of this, but no. And then there's a third piece, which is if it's a accident or injury related to workers' comp, which isn't here, then that's a whole nother
Right, but it's not here.
step down, no.
Okay. So anyone have any questions? Any other questions on the lien process? Alyssa?
I think I still do, even though, just because I want to understand it, the days.
Sorry. The days.
Yeah, so I'm unclear. So hospital bills the patient's health insurance, they get paid, they have deductible afterwards. They have 120 days. The hospital. Hospital has 120 days after they've billed the patient's health insurance for any amount to be owed. They have 120 days to file a notice of lien.
Mm-hmm.
What if, okay, so if a patient who's injured in, say, a motor vehicle accident, maybe it's been 6 months and they haven't even filed a claim against their, so I guess what I'm saying is, what if there's nothing to file a lien against because it doesn't exist yet, and now you've passed the 120 days since the health insurance paid?
Well, liens can be filed without a claim being, a third party claim being made. And that's what happens not routinely, that happens now.
Okay.
So you come in, you say, I was in a car accident, and the hospital will say, oh, well, this is potential for us to have a lien on this, and we recover maybe more than if we health insurance. So we're going to do that. We're going to assert the lien, not charge health insurance at all, and just wait to see what happens. The pendency of that potential lawsuit. So that can happen.
So you can file a lien on a lawsuit that doesn't even exist yet?
Yeah.
Oh,
You're putting the people the person that's injured on notice to say, we have a claim. If you do bring this, we have a claim to it.
that answers
So,
my question.
yeah.
Any other questions for David? Okay,
All right.
thank you.
Thank you.
Do you still
Thanks.
that's fine.
I don't think
Come on up and just say something.
healthcare advocate.
Smile since you've been at the end of the table.
15 minutes with advocate. I think the only thing I would add is that in part of the story is in Senate Judiciary, if I'm remembering right, this topic came up and it sounded really complicated, and they said, go work on it. Senate Citizen Bill work on it. A little working group developed that was Boz and the no longer Tribal
Vermont Association for Justice.
Vermont Association for Justice and Blue Cross. And I pounded it out and came up with this compromise. And it's not perfect from, I think, anyone's perspective, but it's a compromise that we also.
Any questions for Mike? Great. That took a lot less time than I thought to see. All right, so let's stick on 206 for a little bit. So if everyone is looking, it was, it's on today, under Amren's name, it's the Lions proposal of amendment. You remember Ameren walked us through it yesterday. So these are all things that the Senate added to 206. The new language, different language from ours slightly for the Federal Qualified Health Centers working with DEVA on Section 4. Section 5 was the Blueprint for Health payment language that we in this committee had originally put in the budget. It's out of the budget, it's now here. So if we still want it, it's here. The repeal of the repeal for the 340B. Section 7 is all the liens. And then Section 8 is, and Section 8 is the transformation language that we've talked about, that again, Senator Lyons and I had put in the budget, but now it's here. And then the effective dates.
And that was a question about why the lien date.
Oh, can you answer that, David?
Sure. David, I guess I didn't have to come up.
Yeah, you're fine.
David McMurd, Vermont Association for Justice. The delayed effective date on the lien piece was to give the hospitals time to get up to speed and change their policies and practice. It just made sense to give them a little extra time for that, so.
Okay.
Yep.
Great, thank you.
Sure.
Is that good, Leslie?
Yep.
Ameren, so then, it passed second reading in the Senate today?
For the record, Ameren Abergele Legislative Council, it did pass.
And there's no other changes? Okay. Can we straw poll this if it's still in the Senate? Why not? Yeah, okay. Okay. Any other questions on 206, and are people comfortable with taking a straw poll and whether or not we concur?
I have one question. You talked specifically about FQACs. How does the, I think they call them, I don't know what they know. I was on the board of directors, one of them, too. The free clinics.
So
How does this affect them?
This doesn't affect them at all. And so we had put more money in the budget for the free clinics.
Yeah.
That's still in the budget as of right now.
Okay.
But then none of this affects them.
Okay.
Yeah.
Just like, if you don't mind, open the window.
Oh, please. Yeah, there's a little stuff in here. Any other questions? And one uncomfortable voting on 206. You ready? Okay. I'm gonna wait for Art to sit down.
Oh, sorry.
That's okay.
Leave it up if you want.
Is Brian on the? No, he is testifying in another committee. All right, all those in favor of concurring with the Senate on H206? So that's everyone. Okay.
So when I report it as a straw poll or a regular?
Straw poll.
Okay,
10-0-1. Awesome.
thank you.
You're welcome. So at 2, let's take a break. Let's go